case KHAU, YAU and Kinam Reality Development Berhad. Fact of the case, Tengku Sepiah was the registered owner of a piece of land which she sold and transferred to Futo Trading Sdn, who was to develop the land for building. Futo Trading Sdn made an arrangement with the defendants, which is Kinam Reality Development Sdn, for the development of the land. And the defendants were themselves the registered owners of another piece of land, and this was also to be developed for building. The plaintiff KDY has made booking in respect of lots on the land and had signed booking application which contained the terms and conditions of booking. Application was made for subdivisions of the lands, and approval was given subject to reservation of certain lots for bumiputra. So the plaintiff sued for specific performance of the sale of the lots of the land. However, one of the claims by the defendants to dismiss the case, which is there was no concluded contract on which an action would lie, and the defendant were not the registered owner of the land when the bookings were made. Such a contract were illegal by virtue of Rule 11, 1 of the Housing Developers Contract and Licensing Rules 1970. So, issue of the case is whether the developers has failed in their liabilities, and such the booking concluded in the contracts made between developer and the plaintiff is illegal by virtue of Rule 11.1 of the Housing Developers Contract and Licensing Rules in 1970. In this case, the rules applied is section in 136 of the National Land Code, which prescribe the conditions that have to be satisfied before approval of subdivision is given. And another rule is Rule 11, which are the housing developers that prohibits a licensed housing developers who is not a proprietary of the land upon which the housing development is carried out into entering into a contract of sale of any housing accommodation. However, the court held that, accordingly, the plaintiff in each of the actions are entitled to specific performance, which is an award for damages. The contract was one forbidden by law and therefore void. Accordingly, the plaintiffs in each of the actions are entitled to specific performance. So the reasons of the help is that, first, the defendant should have known that in applying the conversion on subdivisions, the authorities could impose terms and conditions. They could have inserted an express condition that the discharge of the applications would be dependent on the approval to be obtained by the land office, but they failed to do so. On the fact the defendants took the risk of contracting to supply each of the purchasers with a sublot with a building duly erected thereon without qualifications, say one of the building to be erected on the sublot that was subjected to approval by the local authority. The second reason, which the plaintiff, which is will never know that the fact that the vendor was in fact not the registered owner of the land, that would make the performance of the contract illegal. So defendants attempt to avoid their liabilities on the basis of illegality, so therefore the contract is void. So the principle of the case is that the scheme of the Housing Developers Act 1963 and the rules of 1970 is actually to provide measure of protection to purchase the housing accommodations in a housing development against unscrupulous developers.